Today's hearing will be auto-transcribed. So to ensure that we have an accurate record, we do ask that everyone speak clearly and loudly. To speak, please unmute your microphone and remute the microphone when you're finished so that we avoid any feedback or background noise. Please state your name before you speak. Speak one at a time. That way we don't speak over one another either. If needed, I or any panel member may interrupt to ensure proper transcription. And after the hearing, the official hearing transcript will be available on the Office of Tax Appeals website. The hearing transcript and the video recording of this hearing are part of the public record. Please keep that in mind during your presentations and avoid sharing sensitive information. Now, the Office of Tax Appeals is not a court. It is an independent appeals body that is staffed by tax experts and is independent of the state's tax agencies. While the Office of Tax Appeals is not a court, we must nevertheless follow certain guidelines to ensure that we establish a proper record on which a decision is based and to conduct an orderly hearing. So today, each party will have the opportunity to be heard. So please wait for your turn to present your side. Also, I may interrupt if we get out of order or become counterproductive in order to keep us on track and to create a clean and efficient hearing record as part of my role as the lead panel member. Okay, now, are there any questions from either party before we go on the record? Okay, judges, are there any questions? Okay, seeing none. We are now opening the record for the appeal of Amalfi Coast Insurance Services, Inc. Case number 231014520. This matter is being held virtually before the Office of Tax Appeals. Today's date is Wednesday, August 20th, 2025, and the time is approximately 3:50. My name is Erica Parker. I am a hearing officer with the Office of Tax Appeals, and I will be leading this hearing today. On today's panel, we also have administrative law judges Sarah Hosey and Veronica Long. While I am the lead for the purpose of conducting this hearing, all three panel members are co-equal participants in deliberating and determining the outcome of this appeal. Now, at this time, I'd like to have the parties introduce themselves for the record, starting with appellant. Can you please unmute yourself and introduce yourself?
Hi, my name is Orlando Frasca. I'm representing Amalfi Coast today.
Thank you, Mr. Frasca. And respondent, Franchise Tax Board, can you please introduce yourselves?
Good afternoon. This is Paige Chang for the Franchise Tax Board.
And Maria Brosterhouse, also for the Franchise Tax Board.
Perfect. Thank you, Franchise Tax Board. Okay, as stated in the minutes and orders, there are 4 issues to be decided in this appeal. 1, whether appellant has established the accuracy-related penalty based on a federal determination should be abated for fiscal year ending October 31st, 2013. 2, whether appellant has established reasonable cause to abate the late payment penalties for fiscal years ending October 31st, 2013, October 31st, 2014, and October 31st, 2015. 3, whether appellant has established reasonable cause to abate the underpayment of estimated tax penalties for fiscal years ending October 31st, 2013, October 31st, 2014, and October 31st, 2015. And 4th, whether appellant has established a basis to abate interest for fiscal years ending October 31st, 2013, October 31st, 2014, and October 31st, 2015. Mr. Frasca, do you agree these are the issues on appeal?
Yes.
Perfect. And FTB, do you agree these are the issues?
Yes, although I had one clarification question. For the third issue regarding the estimate penalty, the phrasing for reasonable cause, the estimate penalty doesn't have an exception for reasonable cause. And so I believe the statement for the issue should be whether there's a basis or a legal basis to abate the estimate penalty for the third issue.
Okay, I do believe I may have had a typo, so I will reread that one then, that whether appellant has established a legal basis to abate the underpayment of estimated tax penalties for fiscal years ending October 31st, 2013, October 31st, 2014, and October 31st, 2015. And Mr. Frosco, do you still agree that those are the issues?
That's fine, yeah.
Okay, perfect. Thank you, FTD. Let's discuss the admission of exhibits as evidence. Appellant has submitted exhibits 1 through 7. Exhibits 1 through 6 were identified in the minutes and orders, and FTB did not object to the admissibility of exhibits 1 through 6. Therefore, appellant's exhibits 1 through 6 are now admitted into evidence. However, I did overlook exhibit 7, which appellant had submitted. It was a copy of one of the notices for fiscal year ending October 31st, 2014. FTB, do you have any objection to the admission of exhibit 7?
I just wanted to clarify which exhibit it was. It's a notice for the fiscal year ending 2014.
Yes, it was the final page of appellant's submission. It's the estimated tax penalty claim for refund denial letter.
At the final page, I'm seeing in the PDF document a estimated tax penalty denial, but for taxable year ending 2013, that's not correct?
There should be one for, you're only seeing the one for 2013?
I think so, yes. The total number of PDF pages is 4 for the appeal letter that we have.
Okay, these are all the copies of the Franchise Tax Board's notices that were sent to appellant. Let's see. And they are I'm sorry?
Oh, I was just going to add that FTB does have its notice for the 2014 ending taxable year. It's dated August 11, 2023, the estimated tax penalty denial. We do have a copy of that, yes.
Okay, thank you. And do you object to the admitting of that into evidence?
No objections, thank you.
Okay, thank you. Then Exhibit 7 is also entered into the evidence. FTB has submitted exhibits A through II. Appellant did not object to the admissibility of these exhibits. Therefore, FTB's exhibits A through II are also admitted into evidence. Now I'd like to discuss the witness testimony today. Mr. Frosca, you indicated you'll be making an oral presentation or providing witness testimony on behalf of the appellant today. I'd like to confirm whether you plan to provide witness testimony in your presentation, because if you do, I will swear you in before you begin so that we can take account of any of your factual statements that you make during your presentation.
No, just oral.
Okay, so you will not be offering testimony, so we will not be swearing you in, and we will not consider your statements as testimony, so we cannot give it evidentiary weight.
Okay.
Okay, perfect. Now with that, I think we're ready to begin. Does either party have any question before appellant begins his presentation? Okay. Mr. Frosca, you may begin whenever you're ready, and you do have 15 minutes for your presentation. And right now the time is 3:58. Go ahead and begin.
All right. So if I'm going off on a tangent, please let me know. I'm not an attorney, and there's not enough money at stake for me to have a hired attorney, so I don't necessarily know the 100% correct procedures as I should. So just correct me. However, all the past due taxes and the penalties and whatnot were all paid right? And this hearing is because I believe I was charged incorrectly on the penalties and the late fees, because the IRS did agree with me and did reverse what they had initially charged me, which of course is what the California State Franchise Tax Board uses to determine the tax liability for the state of California. However, I was never told from the state, from the tax board, that there were additional taxes or additional penalties due until approximately 8, 9, 10 years later. Hence, I think that was an extraordinary amount of time for these penalties and interest to accumulate without having gotten a letter or some kind of notice from the state of California after the IRS agreed with us when we were appealing on our audit. That's my statement.
Okay, does that conclude your presentation?
That concludes the presentation.
Okay, thank you. Panel, do you have any questions for the appellant? I'll start with Judge Hosey. Do you have any questions?
No questions from me. Thank you.
Okay, Judge Long, do you have any questions for appellant?
I have no questions at this time. Thank you.
Okay, thank you. We'll go ahead and move on to FTB's presentation. Ms. Chang, we are now ready for your presentation, and we've allocated 10 minutes, and you may begin whenever you are ready.
Thank you. Good afternoon. My name is Paige Chang, along with my co-counsel Maria Brosterhouse, representing the Franchise Tax Board. The issues on appeal today are as follows. First, whether appellant has established a basis to abate the accuracy-related penalty for the 2013 taxable year only. Second, whether appellant has established reasonable cause to abate the late payment penalty. Third, whether appellant has established a basis to abate the estimate penalty. And lastly, whether appellant has established any basis to abate interest. Turning to the accuracy-related penalty first. When a California penalty is imposed based on a federal examination, the penalty is presumed correct, and the burden is on the taxpayer to prove that it is erroneous. Here, FTB imposed an accuracy-related penalty based on the federal accuracy-related penalty imposed for the 2013 taxable year. The accuracy-related penalty was imposed on the basis of negligence, since there was not a substantial understatement of income tax. Although there are defenses to the accuracy-related penalty, the appellant did not raise arguments for the abatement of the penalty. As well, a review of a recent federal transcript does not indicate that the IRS has abated the federal penalty. Therefore, appellant has not met the burden of proof to establish a basis to abate the accuracy-related penalty. The late payment penalty is imposed when a taxpayer does not pay the total amount of tax due on their tax return by the payment due date. Here, for the 2013, 2014, and 2015 taxable years, appellant's respective tax liability for each tax year was paid late after the due date. Therefore, FTB properly imposed the late payment penalty for the 3 tax years at issue. When the late payment penalty is imposed, the burden of proof is on the taxpayer to establish reasonable cause to abate the penalty. Here, because appellant did not provide any reasonable cause arguments, appellant has not met their burden of proof to establish that the late payment penalty should be abated. The estimate penalty is imposed when a taxpayer fails to make timely estimated tax payments. Corporations incorporated, qualified, or doing business in California are required to make estimated tax payments, and corporate taxpayers must pay at least the minimum franchise tax as an estimated tax payment. Here, for taxable years 2013, 14, and 15, because FTB did not receive any estimated tax payments, FTB properly imposed an estimate penalty for each tax year. Appellant did not provide any argument that the limited exceptions to the estimate penalty apply in this case, and there is no evidence to indicate that any of the exceptions apply. Therefore, the estimate penalty cannot be abated. Lastly, interest is imposed when tax is not paid by the original due date, as is the case here. Because appellant has not provided any argument and there is no evidence to indicate that any of the waiver provisions to interest apply, interest cannot be abated. because appellant has not met their burden of proof to establish that the accuracy-related penalty, the late payment penalty, the estimate penalty, or interest should be abated, respondent's actions should be sustained. Thank you. I'm happy to answer any questions.
Okay, thank you, Ms. Chang. Panel, do you have any questions for FTB? I will start with Judge Hosey.
No questions from me. Thank you.
Judge Long, do you have any questions?
I also have no questions. Thank you.
Okay, thank you. I also have no questions for Franchise Tax Board. However, at this time, I do have a question for Mr. Frosca. You mentioned that there were no adjustments made to the IRS from the IRS. In
There were.
FTB, I'm sorry, hold on. Let me finish my question real quick.
Okay.
In FTB's presentation, they mentioned that in the latest IRS transcript for 2013, tax year ending 2013, that there still does reflect that there was a penalty assessed. Do you have any answer or any explanation for why there would still be a penalty?
So the answer to your question, no, because there was no, the penalty the IRS assessed was after the audit. They assessed a penalty on the lower amount of tax due, which we paid, including the penalty, right? However, yeah, that's to answer your question. Let me know when I can.
Okay, perfect. That was my only question for you.
Okay.
And considering the other judges do not have questions, I would like to go ahead and give you the opportunity to close with your rebuttal.
Yep.
So you do have 5 minutes and you can begin whenever you are ready.
The only question I have, we did send over a letter with the original appeal we made with the FTB, showing that the IRS reversed all the majority of the taxes and the interest on what they were charging, and so they should have the copy. I'm stunned you guys don't have it. I just want to point that out, but they should have that copy, and I'm happy to provide it again if I have the opportunity to do so.
Okay, I do believe there was a copy of a letter that did mention something about your taxes or the assessment being reversed,
Mhm.
but on appeal, it looks like you've only appealed the penalties that were assessed. Is that correct? And that
I guess so.
Okay. Okay, then that would be why, but we do have a
Okay.
copy of that letter in the file.
They do have a copy of that. Okay.
Yes.
And they're not taking that into consideration.
Well, that was considered, I believe, during the protest period, but on appeal, you've appealed your penalties only.
Instead of the actual tax itself. Oh, okay.
Okay. And is that the conclusion of your presentation, Mr. Frosca?
It is.
Okay, and I'd like to turn back to my panel just to make sure there were no final questions. Judge Hosey, do you have any final questions?
Questions. Thank you, everyone, for your presentations today.
Judge Long, do you have any final questions?
I have no questions. Thank you.
Okay, I also do not have any further questions. With that, I think we are ready to conclude the hearing. This case is now submitted on August 20th, 2025. The record is now closed. I want to thank the parties for their presentations today and their patience. The panel will meet and decide the case based on the arguments and the evidence in the record. We will issue a written opinion within 100 days from today. Today's hearing in the appeal of Amalfi Coast Insurance Services, Inc. Has concluded. And this also does conclude the hearing calendar for today. So thank you all.